That's it. There's an open mic somewhere like that.
You push a laptop or iPad or whatever, make sure you.
Oh, that was it. He turned it off. It was this one. It was this mic right there. Yeah. Okay. Thank you very much, Commissioner. We're just going to dive right in. Just a quick note: all the two zoning consent agenda cases come off consent. No, the case number 4 has come off consent. Will be holding under advisement for May 18th. Is that correct? Yes. May 18th. So we'll hear each case individually, and with that, we'll get started with our briefing. Okay. Good morning.
Okay, District 1, present. District 2, present. District 3,
Present.
District 4,
Present.
District 5,
Present.
District 6, present. District 7,
Present.
District 8, I'm here. District 9, District 10, District 10, District 11, District 11, District 12, absent. District 13, here. District 14, District 14, and place 15.
I'm here.
He's here.
Yep, Warren, Chair.
Thank you very much. Okay, we're going to get started with people.
Okay, so basically just going to pick up where we left off. And Commissioner Young, I apologize to you personally because I corrected bullet point 1 here on the other presentation, but not the one that you didn't present. So for everyone would just ignore where it says no zoning application required right here, that causes confusion.
Can you make it bigger?
I can. Can we move it closer at all? Yes. It is. It is.
I'm going to move it. It's going to get unplugged. So.
You know, when I'm using the lady that I've got policy. Thank you.
I know what I'm going to do.
It should have been, I was too late, I didn't have to choose.
It is. Okay. So this is I think the slide that we left off on last time, where we were basically talking about the number of SUPs for PDs for school percentage, and so on and so forth. And then, okay,
Speak up for him, yes, we can't hear. Sorry.
Okay, so the next part of the presentation, I had basically taken a sample set of proposed PD conditions that we got in for one of the variety of schools. And basically just kind of, this is how it got marked up for the internal staff review that you have prior to the CPC hearing. And these are the types of questions basically staff will analyze the set of conditions, just like the site plans and the other parts of the submittal, and making a concerted effort to determine if a PD is actually needed for the site or if the development of the school can be accomplished under the base code as an SUP. So as an example, so this one, I'm going to zoom in, see it. What we started seeing is that for a big swath of the schools that came in, literally the PD conditions that were proposed were cut and paste of each other. Sometimes it didn't even correct information from one school location to the other, and it was a very standard set of requests. The types of things, a lot of you had questions about what types of things are schools needing special regulations for that might not meet base code. So some of those types of things would be we do see a lot of what you're seeing in letter D right there, where it says steps, handrails, fences, light poles, etc. Parking are allowed in the front yard setback. So a lot of times we get that asked for. We touched on that a little bit last time with the steps, handrails, fences, light poles, all those types of things. And if you recall, we noted that if those things are existing, you don't actually need to legalize them by creating a PD because they are already legal based on non-conforming status. So they get to maintain those things that already might not conform to the existing code if they were legally constructed at the time that the original school was built. So I know a lot of times the school will ask to legalize these things, but it's not actually a necessary thing. Now, if they're proposing something that would be a new build or new steps, handrails, fences, not necessarily fences, but new steps and handrails or other things that might encroach into the setbacks, we can't allow that under the base code unless we do a PD or unless they go to the Board of Adjustment to get that allowance. Or unless we have a complete overhaul of our development code and allow certain encroachments into the setback, then some of these types of requests I think are going to go away at some point in the future. Also to note, these types of things, before we got to 51A, 51A, these things were already allowed encroachments under old versions of the Dallas Development Code. And just over the years, as the code got changed and we got 51A, these types of things that people would standardly expect and often are allowed to encroach in other municipalities, that got written out of our code for some reason. We got with a hard setback and everything over 6 inches, the general rule, everything over 6 inches is constructed and it can't be in the setback. So we've kind of created a situation here that is difficult sometimes. Also, a lot of times, we will see schools come in and designate an amount of floor area and designate a specific height, things that aren't necessarily regulated in the base code for that school. So I think that this body, I know, likes to see those limitations, and that's fine, but we don't have to have a PD for it. Those are things that are not regulated by the base code, but we can put those additional restrictions or limitations, whether it's via a PD or an SUP. So, and the appropriate way to handle that is via the conditions, not just on the site plan or development plan. So We would come in, this blue writing here, we would come in and go line by line with the proposed PD conditions and ask questions back of the applicant. So, part of this is educating on the way that the code is actually applied, and helping them understand, like, you don't actually have a floor area limit here, you don't really need a PD for this, and so on. We don't regulate floor area ratio for these sites. We don't regulate the amount of square footage. We don't regulate the amount of height unless it's near airports or unless the body wants to put a limitation. And while I'm talking about height, I wanted to correct something that I had said the last briefing. Vice Chair Rubin asked some questions towards the end about if, for example, a school was partially a single story and partially double story, is there any way that they could go to permitting to put a second floor on the school and not have to come back through the public hearing process? And I said, at that point I said, no, there isn't a way, but I've slept a few times since then, and I'll do my best thinking when I'm dreaming. So I wanted to clarify that so that you all know a direction to take that. That would only be true if there is a height limitation or a story limitation codified. So if the school went back to permitting with an approved SUP and a site plan, and if nowhere in the conditions did we regulate to limit the stories or heights, and they went to permitting and we're going to stay within that same footprint, they really wouldn't have to come back to us because they would still be in compliance with their SUP. So if we don't limit their heights and they stay within the footprints, there's nothing for permitting to send them back and say, well, you need an amendment to your SUP because now you're going to be over the height. There wouldn't be anything to make that happen. So if you want them to have to come back for any changes, like adding a second story, even if it's in the same footprint, then you do need to be mindful of that as you're making motions and approvals. Do you want to limit the heights? Do you want to limit it in certain areas? Do you want to limit the number of stories? Want to limit it in certain areas? And if you ever have a question, staff is always available to help make sure that those conditions are in the record. So I did want to clarify that. We've had some discussion about the RPS. We won't go into that too much today, but we will, of course, often in the future. Another thing that we often see with some of the schools coming in is this bottom section right here, again with setbacks. Sometimes when staff goes to do a site visit, we're looking at the sites and basically assessing at that point in time what is its level of compliance with our existing code. And often we go out and someone, not naming any names, will have installed a brand new 6-foot fence around the perimeter of the property, in the front yards, in the side yards, anywhere they want. There's no permit, there's no anything for it, and that is now not a non-conforming situation, that is an illegal fence. And so more than once we've had a conversation with the applicant and said, okay, for example, on this one, the new 6-foot fence that's installed illegally needs to be removed anyway. So we have applicants come in and want to use a PD to legalize something that they've done illegally already without authorization from any city department or body. So the correct way to handle that is remove it, go to Board of Adjustment, legalize it another way. But I and staff generally do not support plan development ordinance for the sole purpose of legalizing illegal structures on property. So an illegal fence is not considered to be a justification or compelling reason for staff to support a PD. I see thoughts and questions. Are we going to
Keep going. We'll come back.
Okay.
Please.
So also the base code already has regulations for some of these encroachments. Fences typically are already allowed in setbacks. They do have height limits in the front yard in these R and D and T. They have some limits. They can be in the front yard in these low density residential districts if they're limited to 4 feet in height. So some of the options we've discussed with applicants is, we're not saying you can't have a 6-foot fence, it just can't be in the setback. So you're showing it here around the front of the property. Is there any reason it can't be moved back 5 feet? So now it's not in the setback and you still have the fence that you want for security purposes. Or they can lower the height, which is an option that a number of applicants have taken, or they can go to the wall. Okay. If they are and have a landscape plan, it would need to, from our perspective, meet, but ideally exceed the standard requirements in Article 10. We've had situations recently where schools, for whatever reason, if there's significant utility conflicts, you'll see one of those coming up in the near future at one of the meetings. If there are utility conflicts or other things, be aware that if we are defaulting to Article 10, whether it's SUP or PD, when they go to permitting, if there are conflicts with utilities and things of that nature, or any kind of conflict, there are a number of things in Article 10, the landscaping regulations, that would allow them to not plant anything in the area of conflict. So this is one of the reasons that staff tries at this point to identify where are your right-of-way dedications going to happen, where are your setbacks going to be, where are the utilities, where do they exist currently, are you anticipating changes to these? It's very helpful if they've started the plating process, because we'll see a lot of that information in the preliminary plats and in the plat conditions. And if we identify it early enough, then we can work with them and encourage them to have a landscape plan. Even if it doesn't quite meet Article 10, we do have the option of a council-approved landscape plan that deviates slightly from Article 10. It can't be a wild deviation. It needs to be reasonably consistent with the Article 10 requirements. And so there is some flexibility, even when you're dealing with the school as an SUP, we do have some flexibility in that regard. So sidewalks, this is one of the things that very early on when we were working with a big batch of schools, the only offer that we were getting, you're getting a lot of asks, like we want to be excused from this setback, we want to be able to put a 6-foot fence here, we want to be able to put our parking here, we want to be able to do this, and all of these things. And the only real offer that they were providing or suggesting for the community and the neighborhood surrounding was this line right here, that intersections of driveways and sidewalks must be constructed of material that differs in finish and color from that of the particular ingress and egress driveways. That's a wonderful thing. I'm not taking anything away from that, but it certainly is not a compelling justification or a fair offer for the asks. So anyway, so this is kind of the process that we go through when we get a set of conditions. This is, a lot of you have asked, like, why is the review process for a PD longer? Why do you say that it's a longer process? Well, because again, we're writing an entire development code for that particular site. And we have to go through line by line. We have to consider how it's going to interplay with the portions of the base code, where it's going to refer to the base code, where we're changing the conditions, and so on and so forth. And it is a very much back and forth process. So we'll go through several iterations of this, sometimes into the double digits of iterations back and forth when we're dealing with PD conditions. Also, we have, as you've noticed, developed over the course of this journey with schools, journey, maybe a nice, euphemism. The journey with schools to develop a standard set of conditions so that the community that surrounds the schools will be getting a little bit more benefit in terms of some pedestrian amenities, wider sidewalks, making sure we have trees, more than enough trees, and just trying to balance. We know we're a very monstrous size building, often in a single family district. We're oversized, but we belong here. How can we help the community, and what amenities can we offer to the community? So it's important to keep in mind that we're working towards a set of design standards that could apply universally at school sites, so that potentially if there were to be a development code amendment for schools, whether it's, and I know we talked about institutional overlay early on, and I know that language just caused immediate angst. I should probably apologize for that, because we really didn't know a lot about it when we first started talking about it, but we needed to get the topic on the table, I guess. We need to have a conversation about this, because we just need bond packages and have to come back, and it delays their development so long. So it's not necessarily that the institutional overlay is the way to go. It may or may not be the thing that gets amended in the development code. We may never talk about it again. It may not even exist in the new iteration of the development code. It may be that we just amend or talk about how we can come up with sets of design standards for schools in particular, codified into the ordinance, and then everybody knows what to expect, and then we can tweak it as we go side by side. So please understand that this is not something that staff has a firm decision on. We're just bringing the conversation to you and valuing the feedback. And all the emails, which I am now getting emails. Please always feel free to send those to us, and we will do our best to address those. Okay, so now, I think you're all familiar with these. These are just the standard set of SUP conditions that we typically will start to see, or have been seeing in the SUP applications that we bring forward. I think also recently, there have been some additions to this where we clarified information about signs, and basically we have another standard condition that's been added that says basically signs need to comply with Article 7 as amended and are not required to be shown on the development plan. That is something, again, just because we put the condition doesn't mean that CPC has to approve it that way. If you would have a particular idea about where on the site signs need to be, or want to limit signs in other ways, that could be part of the SUP conditions. We just need to have that conversation for a particular site. Trust that you know your districts the best, and we'll know the communities, and then we can have that conversation. We've also started adding recently the EV charging and micromobility stations, and we did have some recent action council with respect to that. So that's about to be a part of base code anyway. I envision that we won't need to be adding those things because it's going to be part of the requirement based on building code requirement anyway. So but that's been added. And then, like I said, pedestrian amenities, and also then I wanted to talk about the new standard traffic management plan conditions. So what you're seeing here in red There's been a lot of concern about compliance, and staff shares the concern about compliance with submitting traffic studies when they're due. And prior to the addition of what you're seeing in the red box here, there really wasn't anything that triggered a return to CPC at this point. If they didn't turn in their traffic study, they just didn't turn in their traffic study. And until they applied for some new zoning action or applied for a permit, and then somebody looked for their most recent traffic study, there was nothing that triggered it. So we wanted to make sure it got triggered at an earlier stage in the process and maybe didn't get carried on so long with non-compliance. So we've added this, that if they don't submit their traffic studies in a timely manner as required, that needs to be reported to the Planning Commission as well. So what's in red is new with the new standard set of conditions, and it mirrors what you already saw in the blue box at the bottom here. It's the exact same language where before, if they didn't submit the traffic study, they just didn't submit the traffic study. But if they did submit the traffic study and staff told them you need to update your TMP, if they didn't up their TMP within 30 days, then they got reported to you. So it actually kind of inadvertently rewarded not submitting traffic studies, because if we told them they needed a new TMP and they didn't do it, then they could get tab on. So now we get to tab on them more than just once in the process. Anyway. And as we've discussed before, there is the ability to amend that traffic management plan through the minor amendment process. So having said that, you've seen most of these before. I think everyone is fairly familiar with those by now. So zoning tools for schools, future options. This is where we're talking about where do we go from here with the mess that we've created for us. So you'll see a lot of TBDs because we don't know the answer to that. There's a possibility of development code amendments and process change. I would say process changes, that's not a possibility, that is a must happen, because one of the primary issues is the inability of the neighborhood and even city staff to locate, for example, a traffic management plan if one does exist. So we've had a variety of internal conversations. I don't know the status of where those are, but there is work in progress to get those to a public-facing location somewhere on our GIS map. You can go to location, you can click on it, and you can see if there's a TMP. You can see the status of it. You can pull it up. You can read what it's supposed to be. They are supposed to. You can also tell your constituents those. The SUP is required to be posted on site. So if you wander into a school and there's an SUP certificate posted, you can ask them where it is, and then they will say, well, what? I don't even know what you're talking about. Because every time I've gone to site visits, there's a big disconnect between what happens here and then what the on-site administration ends up knowing about what happens here. So they aren't necessarily familiar with the fact that they're supposed to be posting the SUP certificate, or that they're supposed to be submitting traffic studies. Anyway, so if you were to happen to wander on and request to see that, it's supposed to be posted. And that would include, I can't speak for all of staff, but when I create that SUP certificate, I put all of the conditions in there. That means all of the traffic conditions are in there, meaning including the requirement to submit traffic studies every 2 years on total. So it may be that there's code amendments, there definitely some process changes, and something else entirely that we haven't even considered yet is certainly a possibility. we don't know yet. Okay. With that,
Ready for questions?
yes.
Questions, Commissioner Blair, please.
We're going to start with TMP.
Yes, ma'am.
What if the TMP is not suitable, although it is posted? How does that, the suitability or non-suitability how does it get it back to CPC for review and redesign?
So, that is part of the requirement for the every 2-year traffic study submission. So the entity needs to do a new assessment of how the traffic is working at the school, how the operations are working, and submit that to staff. Staff will use that in conjunction with any other feedback that they've gotten from the neighborhood about how traffic is working. So those regular 2-year intervals would be the first place that comes to mind. That's the first thing that might trigger it. But in the meantime, any feedback that would get to staff, whether that's via 311 or a constituent calls a plan commissioner or a council member or something and is just beside themselves with the horrid nature of the traffic operations at the school, if that gets to staff, then that gives staff an opportunity to investigate that and see if operations are working as they need to. I know that David couldn't be here this morning, but David and transportation staff would work with the on-site administration to assess what's happening and discuss the changes that were needed, and that can happen at any time.
And I want to point out that keep on saying this. You also have the zoning power. You can bring back an SUP by the
We have yet to see that zoning power, that opportunity ever exists, because when we try, it doesn't happen. So let me keep going. You said that the TMP, that the TMP will one day be available on the GIS map. Is that not?
That's the goal, yes.
Okay, do we have a timeline, and for that to be do we have a timeline for the TMPs to be on the GIS map?
Yes, and we had a few conversations. I need to talk more. I think it should be held with the Department of Transportation and be part of the 311 map. We're talking to them. It's going to happen. It has to. It's unavoidable.
So,
it's yet to. Let's say this, and I know the reaction. Traffic management plans are an engineering function of the Department of Transportation. They're not a zoning function, so it wouldn't make sense to get them onto the zoning map. But if need be, we can put them anywhere. It is a internal frustration, even for transportation, considering the fact that they receive a lot of 311 calls, or the fact that they don't have the TMP stored somewhere that's on a map or something that is easily accessible. So we will do that.
So, just to agree with you that TMPs should be somewhere within traffic engineering, but we do need to be able to have access to those TMPs if we have the charge of having residents come to either the council member and or the commissioner and says this is not working. Next question, and thank you for adding, Ms. Algado, for adding the SUP conditions on your certificate. I've seen the certificate, and most of the certificates I've seen are just a certificate that says you have an SUP, but it has no documentation that SUP can be to be a dog catcher, if, you know, as far as we're concerned, because it's just a SUP and a number.
Right.
Is there any plans? And I guess again, this may be more along the lines of Dr. Rivera. Is there any plans, or is there any thought to have the SUP, just like you can go on the GIS map and see the PD, then you can go to the city attorney's website and get a copy of the PD. Is there any plans to do something of that nature with SUPs moving forward?
Yes, we're in the digitization contract, finally got a business manager for we're in review for records and.
So embarrassing.
Okay, I didn't hear what you said. It's not, but I'm trying to say that it does, so we have an ongoing digitization program, project that we need to be, and we are part of. It's just that I need the staff, I started to have the staff right now. So they will be, they're already digitized, it's just that they need to be in some sort of an acceptable archive. So we're gonna put all our stuff into OnBase, we're working with GIS to link them. So we're getting there.
So can you share with all of us in the meantime, if we need copies of an SUP for this process? I know I have the heck out of your manager. Is there a better source? Because he's not a good source, because that takes him away from it takes him, no, honestly, it takes him away from what he really needs to be doing. Is there a better source that all of us can access in order to get the same thing without disturbing his work?
Yes. Liliana Tierica, our amazing contest lady is Tierica and Liliana, they both. Or you can even ask Yolanda. Yolanda will immediately ask Tierica and Liliana, they can scan it immediately and send it to you. We have some of them. We have a lot of our shared drive, like usually the ordinances are stored there, even a planner can give it to you, so yes.
Well, I just want everybody to have the same access, but I have gone through the same process that I have and share that knowledge, because I don't.
Because that's for anybody who's coming and asking for a thing, for anything that we know it's in ours. We rarely send people to open records request if they want something pointed, like I want this SUP, but if it involves a bigger research and okay, I want all SUPs between this and this, then we would ask them to go through open records. But if I want to be SUPs, and for you, of course, like we would always scan it.
If I can add to that, first of all, it's not a bother if you contact one of the planners to get that for you. Feel free to spread the love around, so that you're not just, any of us would be happy to get that. The other thing is, I noticed the same thing that you did on the SUP certificates. When I first got here, basically it says, you know, the date that it was approved, maybe it's the time limit and what it's for. But I was kind of, well, what's the point of posting it if I can't go look at it and know what the conditions are supposed to be? But it seems kind of productive. So, very early on, it was actually Jen Munoz that I had a conversation with, and she was dismayed by the same thing, that all of the conditions were not put on the SUP certificate. So I have started to the SUP certificate 3 pages long, but I also put page 1 of 3 or 2 of 3 or whatever. So if you go there and you see SUP certificate for a project that I've worked on, you'll know how many pages are supposed to be in the certificate and all of the conditions listed there.
I have 2 more questions and I'm gonna be done. Can you take that process that you're using, share it with your peer group and have them all do so that's for consistency? And then my last question has to do with TMP through the minor amendment process. Your minor amendment process, we don't have much flexibility with. With our minor amendment process, we are basically required to approve them when they come before us. Is there any, if you're using the TMP through the minor amendment process, what gives us some assurity and or some authority to have the TMP actually reflect what the needs are for that particular community, opposed to just saying, because this is the process, here it is, approve it and move on.
Well, I'm a little bit confused. So first of all, like TMP can come from the minor process, but can also be a full renewal or a full amendment. So you can change it again. There are ways, it's not locked in. But then again, the TMP, the traffic, is a function of engineering transportation. So we're gonna have to find solutions to make it work. Either limit the operation in a way, like we're gonna have to find solutions. It's not, if you want to deny, obviously you can deny as well. So it's, that's why I'm engineering and traffic is gonna follow whatever use and whatever type of intensity of operation we put in there. So I think we have enough maneuvering.
Yeah, it's a little more fuzzy with traffic because there's not a clear code of does it comply with. It's an assessment of the site based on traffic studies. And so that it's not the same. Whereas we can just look at the base code.
Commissioner Blair, I think you might have been asking a different question. I think I understood what, which is, I think Commissioner Blair is asking, her concern is that will TMPs ever become an administrative function where we get them and there's not a possible way to say, well, you know, we do need to make an adjustment, et cetera. Or it's a binary thing, yes or no.
I would say that by nature, they have to be administrative. The fact that it comes to a public hearing, that we understand the public input, we get it anyway. But at the end, it's still like the same at every engineering function. You have to do it. There is no way out of it. So it is an admin function. Now it's subject to a public hearing because that's how it is. But I cannot, like, I don't think we ever made a determination regarding TMPs. We're gonna continue to work with what we have right now. But like everything, like this is the rule, you are not allowed to queue on public streets and that's it. Like you're gonna have to make your operations work.
But you have actual TMPs that we're seeing even today that says the article says you're not to queue on public streets, but you look at the TMP and all the queuing is on public streets. So until you have consistency and equity, you can't put a process in place and ask us to follow a broken process.
Well, and by the way, just to clarify, there are some streets that have to queue on the street, right? They're just, the footprint makes them impossible, in fact, to get cars. I have at least 6 in District 5 that are just impossible, right? We're going to put them somewhere out and it feels, it just can't be done. But I think I understand what you're asking, and I understood the answer that you can absolutely make adjustments. It's not like, you know, a development plan where it's a binary question, yes or no. This is a process where you can say, well, you know, we had an adjustment made to a TMP today, in fact, last night. Probably good about that. Commissioner Stanley, follow that, Commissioner Farmer.
Yes, I am. And I'm doing catch-up ball. I was not here at the last hearing, so I hope I am not repeating things. But I'm not going to, I will go with TMP, but I do want to ask you, preface one thing while I'm asking you. Kind of like Commissioner Blair was saying, I have lots of schools that we've worked on in District 13, but everyone has schools. And one of the things when we talk about this, no one wants a school SUP almost fill in the blanks more than I do, so that it can move faster. On the other hand, you know, every school is so unique, and one of the things are the parameters of, you know, the property. Okay, so given that yes, we would love for them to follow every single inch, you know, setback, but we have situations, and you've seen the hours we've had to end up discussing these situations, where it is not possible to do that. Same thing with the queuing, that you've got to go with what you've got. They can't add extra lane. They're dealing with what they're dealing with. So given that, let's go to one of your examples, because this concerns me. I understand that the PD process should not be used, and I like the way you put it, to legalize that which is illegal, okay? But on the other hand, I want to see from the city as much flexibility towards schools as possible. This is what the taxpayers' money is going to. There's nothing more important than education. And again, they've got parameters and restrictions. So in your example, you used the fence. And you said, okay, we get there and here's a 6-foot fence and it's all the way up to the basically property line, let's say, not within the setbacks. Well, they would have to remove it. Here is my question. Is that what we really want to happen? Is there not some middle ground? My concern is, have we done anything good for the school removing it? Can we find a way that the front portion can be lowered and moved in? Can we work with schools? Because I don't like this idea that we are becoming so legalistic that those things can't happen.
So that is what we do. So they don't have to lower the whole fence. They don't have to lower any of the fence if they get board approval to keep it there. I mean, one of the things we talked about early on with this particular location was, I see that you have this fence, here are your options, right? So agreed that there needs to be some flexibility, but there is flexibility built in to a degree, but we can't create flexibility in the code where it doesn't exist. I mean, so the question is, are we gonna make a PD so that they can have a 6-foot fence in the front yard?
In fact, they can go to BDA, or they can make it 4 feet.
No, I don't want them to abuse the situation, but I don't think a lot of schools have a malice intent where they put that fence up because they were trying to do something against the rules or the code. And I would just hope that with some people that would be taken.
It's not, I don't think it's interpreted as malintent. I mean, it's just a consistent pattern of behavior that things are done sometimes without comment. We know what happens, and when it does, and when it gets discovered, we address it and we discuss options for how to address it.
I just think that we're getting into so many, and I understand it, but so many steps and processes that, going through the Board of Adjustment is not an easy process either. Bringing us to the attention to the school. And then all this, that, and the other is a major thing dealing with the fence. Okay. But
so you'll start to see on some of the SUP site plans where they've considered the options of recessing the fence so they can keep the height. You'll also see some SUP site plans where it's called out that in certain locations it's 4 feet, and certain locations it's 6 feet, and they make it work. One part of the issue is when we first started this conversation with our main ISD, it was interesting because their construction directors in their Ron's office, there was a lot of confusion on their ends that they didn't really understand the options that were available to them. And so part of this was an educational process of staff helping the ISD officials, not just their representatives, but the officials with the ISD thinking long term so that the next time, we have a swath of schools come through, there's a better understanding in their office about how to guide their consultants. I heard more than once, we get a site, we know we're going to do a full, or we're going to do this. What is it I need to tell our consultants that their parameters? And for a long time, decades, they were told, just do whatever you want, we'll get a PD. And those started getting really watered down, really cut and paste. And it wasn't really necessary because when we talked to them, basically, we can give you this set of standards in this location in the code book, because if you do the SUP, you can always refer to this document. So in some ways, it's simplifying for them what they tell their consultants. if they don't know what the parameters of the site are gonna be, if it's gonna be different everywhere, because we're gonna create a new PD, and this one has 17-foot setbacks, and this one has whatever. So they wanted a consistent place to go look.
And I agree with that, except I have an exception to that.
Okay.
I think that idea works perfectly with new construction on a new plot of land. Okay. You're starting with a blank slate, you can build what you want. Most of our things have been where you're keeping a school going while you're building the new building. We've seen that more often than not, okay? And under that situation, we had a case, I can't remember which one it was, but where we started talking about 2 feet of setback when they're trying to build a school on another thing. That's where I think we're getting, where we're trying to conform everything. When you're dealing with something that already exists, is there a process in this SUP process where in that case, yes, is it exact? No, it's 1 foot different than what the code is requiring because of the restrictions of that site. Can we do that? What's the SUP?
I would say that, again, if it cannot and it's warranted, and we all make an assessment as with the applicant, make an assessment that this tool doesn't work, then we move to the other tool, which is a PD. So you'll see we're gonna have a variety of schools coming with PD amendments in the next 5 or 6 schools. Or it can be, yes, we understand this is the situation, like it is your.
So what you're saying, just to clarify, and I hear you, what you are saying, because I want to have a couple other things and I'm going to move on. You're saying that this is what I want to make. Does this happen at planning, that if they're asking for sort of a quote waiver on something, they are advised to go PD route because it's non-conforming? So, or they know instead of the SUP, or does it come to us as an SUP and we say no and they have to go back and do a PD?
It's a site-by-site assessment of what their needs are and what the existing conditions are. And I hate to say this, but I mean, I don't. I mean, it just depends. So part of what we would like for you to understand is we're not saying that you can only do an SUP, that is the only thing staff will consider, period, full stop, end of story. That is not what we're saying to you. What we are saying to you is we're doing a more thorough assessment of every site and discussing in detail with the applicant what their options are, what they can accomplish with each tool. And if it becomes evident that the only way to accomplish what they need is through a PD, then we will do it.
Okay, so you are going to be some planning department, that's what I'm going to know. But when they come, because I heard from the school side, from the other side, both public and private, that they didn't understand the SUP process, they didn't understand what they could do, what they couldn't, they found it limiting, and therefore, even for one deviation, they had to go the PD route. So I'm hearing that. So what you're saying is you will make a determination whether this can fit the SUP model to meet all of their needs. And you are willing to recommend they go PD if they're asking for some exceptions.
I would just make a little note of that. That's what we do with everything. We have consultation meetings with Donna, students, for Jennifer, Alicia, Hannah. That's what we do. Like we do at intake, we make sure that they submit everything. But before submitting, they come and ask for consultation with us. They tell us, I want to build this. What is your opinion? Show me what I have to do in the code, and then what is the tool to get me there. So usually we try to do that. I would say that 50% of the cases we advise every applicant what is the suitable tool. Is the general zoning change, is the PDs, and then we do that with everybody.
Well, I'm going to leave the message.
Yeah, so I think really what we're advocating for here is a new policy moving forward for schools. And Jennifer and Andrea can correct me if I'm way off base here, but we're advocating for a new policy, but it would be a policy just like any other policy. There are going to be exceptions, you know. Am I off base there? Yeah. So
yeah, because a lot of said to me, and maybe they didn't understand, I'm just a messenger. It's not what I'm proposing. They said, we were told we had to do an SUP. And I just want to make sure that everyone understands that there is the option still, if you've got specific needs and parameters that don't allow you to go the SUP, that you are offered the possibility of going a PD to meet your
And that's
immediate
really,
needs.
that's really the nature of this process, this zoning process, really of what we do is, you know, it's projects that are proposed to the city that don't meet the current zoning, whatever that is. So they come to us, as Jennifer and Andrea said, we assess, you know, what we consider the best course of action to be, and we make that recommendation to you guys as a body. But this whole process, by nature already, is discretionary and allows for flexibility. But we can certainly, within that process, establish new policies and best practices and all that kind of stuff based on our professional opinion.
And I would also just like to gently remind everyone that this is a political process and political things happen behind the scenes. And so I just think maybe you need to take some of the information that you have with a grain of salt, because people have an agenda, they want to do certain things, even if there's another way to do it, because a lot of, ultimately what comes to us a lot of times is, it's a design problem. It's not that they can't do it, it's that they haven't found the correct design solution for it. Now, in the very beginning, we got a bunch of schools where they were so far along in the process that they were scared to death to have to do any redesign. Staff advises, and understand it's an expensive proposition, it's time consuming, but in the long run, in some cases, you all or council or both have ended up forcing that issue because what they're proposing isn't a good solution for the sites. And so we advise them to the best of our ability based on what we know of the site, the conditions, of the code. Just there's such an open process, but it is false that they have ever been told you must do this.
Nobody is trying to jump, nobody's trying to blame anyone. I just said, I'm just the messenger. And that's what they're saying. Say in fairness to schools. My only objective about this is not to criticize, it's to say we need to find a way to speed up the process. That's what we're all here to do. Because schools shouldn't take 12 and 14 months and this, that, and the other to get through this process.
And that's another part of why we're advocating for this policy. Andrea and I have had conversations about the fabulous work that Jennifer's done almost for a year now on this. And, you know, Andrea and I have kind of discussed it in terms of, okay, we've been prototyping and now we're ready to move to like franchising, you know, because we do all these high-level conversations. Jennifer, with all of her expertise, has dug so far into all of these issues and codes and all these sorts of things. And that's been some great work. That's all the R&D, and now we're ready to advocate for this standard policy that we believe in the code will pretty much establish an assembly line, you know, in cases.
Yeah, no, and I think that would be great because it does need to move on.
So I would like to say, as an example of how that's worked, there was a recent planning commission meeting where you saw several planners handling school cases. That's because we got to, like Ryan said, we got to sort of a prototype. We had sort of a working relationship established. We basically sat down as a team and talked about, okay, these are the next 6 schools that need to go. We divvied it up among planning staff so that we could bring more at the same meeting. And that's the idea. And then also, just to give you, put some numbers to it, we had a school go from staff review to CPC in 10 calendar days. Right? So the process, the improvements that we've been working on are working, but we can't change the fact that the schools we have in now were submitted whenever they were submitted. We didn't have this process in place, but it's working. So I just want to let you know that we're mindful of the same.
No, and I thought that when you spread it out, it worked great. Then I want to move on to the TNT.
Well, let me take a couple other questions, Commissioner. We have three other folks right behind you. But interestingly enough, Jennifer, my very first day as a planning commissioner in this very room, in fact, in that seat, the very first thing I learned was that the P in P and Z does not stand for planning, it stands for politics.
Yeah.
Very early on.
Yes. Real sense.
Commissioner Carpenter. That's one.
First of all, I can say that only yesterday did I send this out our, got 100 questions.
You've answered all of it.
Completely my fault because I kept waiting to get to the shape and I finally said it several times, but to just touch on a couple of them. When do you know, because you're saying that when you're having your initial consultation with school cases, you have a series of questions, get an idea of whether you go the SUP route or PD route. Can you share with us some of the triggers, the factors that you know immediately drive the school into a PD? If it's already an existing PD, we're trying to save a legacy building. I mean, it would be helpful to me to know what some of those things are.
Yeah, you've mentioned two of them right there. So to save a legacy building was a compelling justification for PD at Geneva Heights. And staff had no issues supporting that. It's something we couldn't accomplish with an SUV.
That's what they were.
Yeah, if you have existing PD also,
Right.
then I don't know, like they haven't, if it's a new build, but then if it's an addition to say you keep the existing school and then it's absolutely impossible because you still need to serve the kids and you need to provide the bigger building or something. But we always try to say, okay, let's see what can you do if you comply with the code and where are the shortcomings, and if not, then we can always. I couldn't like. Up to now, I didn't find a school that was like, oh, this must be a PD. But if, again, we will have to do this.
So if it's once a PD, it's always going to be a PD. If we have a school established under the PD, or is it a plan?
It's always to get them to like,
Yeah, so
that would be and like, you
Yeah.
already have it, you already have it.
They're the same as the PD and it's supposed to be demolished. It's still to be ready to stay with PD.
I would say
I
so.
mean, if it's there and it works, and I mean, it wouldn't, I mean, I'm thinking we've had one school where the applicant actually had recently created a PD, and they approached us about going back to the base code and doing it as an SUP instead. That's the only time that there was one case, and it hasn't come through here yet. There was one case I can think of where that was even discussed, but as a general rule, it's been the policy of staff that if it exists, we roll with what we have, and where the PD does not live up to some of the new standards, we upgrade it.
But the legacy buildings, once you get bigger, that's the biggest trigger for staying with PD. I would that's no way to accomplish that through the SUP.
Not that.
I think that's putting an age on it, which I would love.
Right.
I know, I'm trying to say, like, you need to real this in a real
Process.
Moving on to that, the question about fences. I know schools have, you know, they report to higher authority than us as far as school safety guidelines. Yes. So I don't think secure vestibules and things like that. And one of the things that needs to be founded on is 6-foot fences. Do we know what the rules are for schools? Are they required to have 6-foot fences for safety now in certain
No,
locations?
I think what it is to state is, there's some sort of scoring system or something that comes from the state that they get points. Don't quote me on this. But my understanding is that they get points towards, you know, for certain features that they add towards their security score for the site, but it's not that it has to be a 6-foot fence. That's my understanding.
The difference, I mean, Commissioner Blair was alluding to this, and that the difference between a development plan and what the rules are for an SUP site plan. Because with development plans, what we, so they hear us, come before us all the time for minor changes, and we're told that we have no discretion as long as they comply with the underlying zoning. You know, that's it. Even if people want to add the athletic stadium, you know, at that point, we got conditions, you know, we just.
No,
Yeah, it's not, it's not, it's just compliant with the code that it's not, yeah.
Well, we've had stadiums.
Minor amendment.
We're talking about two different
Yeah,
things.
trustee added.
Talking about the initial development plan and the conceptual PD, and that is non-discretionary, correct?
Yes.
Right,
It's,
versus a minor amendment.
yes, it has to, but also the third criteria comes in, like you have the minor amendment conditions in the code. Like you qualify for a minor if you don't do these things, which are like 4 or 5 things. And SUP is the same. You qualify for a minor if you don't do these things. But if you do these things, automatically you're an amendment.
The development plan, and those are the PD, there's a director approval process that behind the scenes, there are certain things that the director can change. My understanding of reading the code is that does not exist for an SUP site plan.
That is correct.
So even so, are we going to start seeing very minor things, say for school? If they have to move down a store, reconfigure a parking lot, I mean,
I would
no
say-
rules can.
and that becomes, let me address that real quick, because this is one of the reasons that we're really careful about what and how we word conditions. So, for example, if you mentioned parking, if they configure whatever, we don't really have, we don't usually put conditions in the SUP regarding parking unless we're gonna, you know, deviate from the base code. And so there's nothing in in a PD, it depends on how the wording is. If it says, you know, parking must be provided in the location shown on the development plan, I mean, there's some discretion in permitting. We're like, well, okay, you're not really moving into some completely new location, but if you're reconfiguring it's the same area, we're not gonna, okay, you're fine. I mean, you're not gonna send that. The same would happen for an SUP. So as long as we're careful with the way we write the language and don't kind of back them into a corner with the way we write the conditions, there is gonna be some flexibility if they want to reconfigure parking and things like that.
Where I'm struggling is, there's no director approval. So to me, that would be a little bit number change that we have, what.
The other thing that we do is when we're working with them on the site plan, they do build some flexibility into the site plan. So sometimes you'll see it as a buildable area, but maybe that one, you know, there are ways to kind of allow some flexibility. So you'll also often see like a future expansion area, things like that, so that it can ensure that they're going to end up with, you know, a faster process later and not be increasing by, you know, extraordinary.
I want to add the fact that the development plan minor amendments, you know, if you have residential adjacency or adjacency in schools, or residential adjacency, it's pretty rare. Like I think I asked Donna to see how many minors we do administratively for schools, and I don't think it has many because they have the residential adjacency.
Something I said earlier about permitting having the ability to all of a sudden add stories in a floor area, or that, I mean, I can see communities going wild that they think they agreed to something. So to me, what that says is in SUP conditions, we need to be very mindful of putting square footage and stories and heights.
Be careful with the square footage again, because maybe they need to build a shelter, like an income weather shelter, which
I to the exact foot, but exactly.
I would say that it would be, I would kind of steer away from the square footage because just standard issue that we see at permitting is that developers don't understand the way that square footage and floor area are measured by the city. They invariably get their numbers wrong and it's too small. And so I would say if you're going to put square footage in, you need to make sure that we put a big cushion so that they don't go over there. And then when we measure from the outside of the wall and they've measured just the conditioned space, and that can end up being a lot of square footage just by that incorrect understanding of the code. I would say the safest way to make sure they come back is to put a story limit or a height limit or both, and to codify them. So if you know that it's gonna be, if you know that part of the school coming through is gonna be 1 story and part of it's gonna be 2 story, and you wanna make sure that it stays that way or they have to come back, then you say, you know, max number of stories is 1 or 2 as shown on the stick. We word it some way that it ensures that they would have to come back. And we are happy to work with you to get the language right so that you get the result that you're wanting for that patient.
I think it's extremely important, considering that we're looking at any legal items, right? Right. Right. I'll ask one more question. With the TMP language, when it says that if the revised TMP has not been submitted, the director has to notify CPC. What does that mean? They email Chair Shadid, they, what is it? What happens?
We need to do it. Let me get together with David and find a way. Maybe we would do like this every 6 months, or I don't know. Like, I need to talk to David about that. And we would probably send it again.
They never do it. I mean, I don't see any teeth in the ordinance. They notify CPC, but
Okay, well, no, there are.
Yeah, what do we do next?
There are pieces of the ordinance that the director shall send the TMP to CPC. And with the TMP, I think the director can also be. I need to think a little bit about it, but it says the director shall send it to CPC.
well, that's it for this one, but if they don't do one, I mean, okay, we get notified, but then what?
Yeah, then what happens?
Nothing is coming in. The reality is that the commission has been approving renewals for SUPs or amendments to PDs for schools that have not been providing their required update. And so we try to make a point, letting y'all know when they come back, whether or not, and we ask them to make a statement acknowledging that they missed their deadlines and a faithful promise for a plan better of how they move forward will comply with the update. I don't think that the ordinance is supposed to be punitive, though. I think it's meant to be more of an opportunity for city staff. I mean, it's a living document. The TMP is not just a document that you review and you hope that works. It's actually one that I get calls from transportation all the time, letting me know, David, is that TMP for X school? And I'm crossing my fingers that there is one. And if I find them, I give it to them. And then we all go out there and we talk to the principal. And then we work through things. If we find that the changes are minor, I don't think that it's worth anyone's time, including yours, to review minor changes to TMPs. But the TMP itself, it's really helpful for a principal to know, oh, I know what I'm supposed to do. Or letting us know, David, I've never seen this. And there's no way I can enforce it. I don't have this. So I do find it that it's very important for them to be a recurring update. Knowing that schools don't comply with that. And I know that's wrong. I just like that better than the alternative, which is the living part of it.
What are your options if there's no TMP or revised TMP on the file and you're getting lots of complaints from the community?
Yeah.
What are you empowered to do with that?
Well,
I mean, other than never come back to us.
may I use examples?
Let me just clarify though, that this is not, there's no difference in this between PD and ordinance.
I know it's for both, but yeah, we're talking about schools.
So they have the same code enforcement. So we've been to several schools with code enforcement. Those are uncomfortable conversations because that means that we were not able to work with a principal. We love principals. Principals are the only person who can submit a request. A neighbor complains and says, I want a new school zone here, and we say, talk to your principal. When we hear from them, we'll go out there and inspect and see if the school zone is needed. Transportation, that doesn't come from me. Transportation staff will not receive any request for anything that's related to a school unless it comes from the principal. When we get complaints, we immediately contact the school principal or the representative. And we work with them most of the time. With a few exceptions, we send code enforcement. And we use the TMP as an ordinance. And we use code enforcement, and we bring them with their badge and say, you have to do something.
But what's the point of having a process where there's nothing that happens? What is the
It
point?
happens, okay, but just need to be implemented to follow up with that. That's
Yeah,
what
but
I'm
I'm
saying.
saying,
I'll
what's
take
the
that.
point of turning it over to CPC and nothing happens, that the applicant doesn't think, well, they're gonna have to come back.
That's what I mean. I want to make sure that the report isn't really I would not want to have schools punished for not submitting a traffic study update when they've been doing it well. Another point that I'd like to make for the record is that we've been accepting traffic updates from schools without an engineering student. That's a directive from our director, in that I'd rather have an update, a conversation with a principal letting us know, David, we submitted it. Yeah, it's main complaint. They say, David, I can't do 23 studies every year for you, and each one is $10,000. And I said, I don't want you to spend that on books instead. And getting off the subject, but I would certainly accept anything that has to do with it, that allows us to have a conversation with the people. Now, if we're not getting complaints from the school, and they're not submitting their traffic study updates, you tell me, is that, are we not doing our job? Because
No, I think the schools should be required in the SUP to post their TMP on their website.
Oh, well, that's another item. I also get a lot of calls from the inside staff, the neighbors, school principals. Where can I find?
See, we've been
That is probably.
We've been requiring private schools to post it online, because we can do that.
Also, the way that the report itself is prepared, and I know that there are different views. I would hope that the report is meant for parents to understand.
Yeah.
Limiting technical information. Now, that this information belongs from somewhere in the report or in a separate report that we as a body, that you as a body and we as staff are able to review. But I'd rather have a report that a parent.
Yeah, the public needs access to
Understand
this.
what it's supposed to,
Right.
how they're supposed to come in out. That's, and we've been called out on that because we want also to have detailed information on traffic studies for schools. I still think that that one page of the report could be straightforward, summarize the thing to a person who just exactly know this is what I'm supposed to be doing.
Yeah, I'm sorry, we're short on time, Commissioner. By the way, we are gonna have a part 3 to this. What?
I'm feeling 10.
So much better, just to.
I'm sorry.
You need a Sherman table.
Three times is not real. 3 times.
Thank you as always for your detailed briefing. I did not think I wanted to touch, but I did want to follow up on that. One of which ones prior to, but to the question of SUP versus P. I guess one thing I'm trying to understand is, am I hearing that as staff is evaluating that there would be consistent, I don't want to use the word checklist, but there would be consistent conditions that we would go through and say, okay, this is what the setback needs to be. Hey, we talked about height, we talked about stories. Is that part of what staff is evaluating as they're thinking about utilizing the SUP process?
Yes, because a large part of the assessment is what do you need in terms of your development goals, what form and function and size and all this you need. And the zoning district that you exist in has a set of standards. Does what you're bringing to us even come close to meeting that set of standards? And if not, then why not? And so then we start that discussion there. So
then I'm going to go one step.
I know where you're going with this.
And then as staff is evaluating that, are there potential for instances where the standard might be above base code? And again, going back to,
Yes.
they've been in our district is typically 30 feet maximum height, but schools are being legal height. There's quite a difference in that.
Right, but I think we as a society recognize that schools have to exist and that they're bigger than single family, right? So we have to recognize.
Is it,
So
I mean, is some evaluation in that regard that staff is evaluating?
if necessary, based on what they're submitting, if they would come to us with an application and a proposal that is just far and away different than its surroundings, whether it's school or not. I mean, how is this building and this proposal fitting into this context? But are we at the staff level going to say you're limited to 36 within heights? I don't really envision that, because based on what they've come to us with, I mean, they don't usually propose more than 2 stories. If they go to an extended height, it's usually because a storm shelter is required. I mean, there's a reason for it, and so exactly. So they need that additional height, and I think that they'll be.
I just think there's perhaps a ring in between unlimited and 30. Close to 30.
So when you each have your conversation with staff, if you have a case that comes up and you have, I'm gonna guess that if you have a school case come up in your district, then I will hear from you. I would hope I would. And let me just put a plug in I would encourage all of you to contact us early, just to kind of touch base and have a conversation and let us know thoughts, concerns, questions, whatever.
And in my case, I don't have as many school cases as some of the other districts. And
Right.
so, while yes, I can drill down into details, but it's also, I think, helpful to understand what's the starting point of the conversation, so that we're not reinventing things that are already been thought of. I guess that's all I'm trying to think about. I won't go back into my setbacks.
But the setbacks and also just I was anticipating that. So there really hasn't been something that there haven't been proposals that would cause us to go, wow, that's really close to the property line, because of their functional needs, their buildings are recessed back on that side setback anyway. I mean, it's a case by case assessment of the design.
And this is going to go back to, I think, something that we're quite fairly right. Again, repeating things that I think everyone's heard me say before. If we're saying that the setback is 10 feet and you're across the street from a front yard, and we're saying that it's any legal building type, yes, we can put in restrictions. I'm just asking, why is the starting point not to say, if we understand just the way that the code is written, it would be 10. However, we think to work within the established character that it should be 25, it should be 20, and encroachments would be allowed, which essentially gets, that, difference between 51A and what I heard you say is 51. Anyway, just to try to make sure I understand how staff is thinking about those, thinking that we may be headed towards a different approach.
I think that when and if there was a code amendment addressing schools, I would envision something like that being a part of the conversation, because we want to allow the encroachments. I don't think there's really any question about anybody going to be bothered by a handrail on the steps. I don't think so. So I think that would definitely be part of that amendment conversation, and I guess as needed. And maybe when we start to get schools that are not already, we're not being told, we've already disclaimed the whole thing, and we just haven't, there hasn't been a situation where we've had to have that very hard conversation about backup. Well, maybe one, Jen has one.
Again, I think to your point, everyone would like some predictability. Neighborhoods, the OSD, teams who are designing the project. So again, that's why I'm trying to think through some of this. Because the final question I just want to ask, again, thinking about in terms of an SUP, I'm just going to ask this.
The smile you have on your face right now scares me.
That's not a nice Close your eyes. Breathe.
I hear very consistently is TMP. That's one of the things we're all saying. It's one of the biggest impacts on, okay, we've all kind of defined the building, we know how it is. they're increasing, student body, whatever it is. Has there been any thought, an initial 2-year period to allow the TMP to come back with automatic renewals for 20? Now, if we typically think about it in terms of it's 10 and 10, or it's 20, or it's permanent. But has there been any consideration of that as a way to essentially build in, there is a check. Everybody in the community has this opportunity to report back, but there's an expectation, look, you're getting it right, look, here's these 2 minor tweaks we need to do. And then we're gonna look at 20 years, we're gonna look at whatever the period is. Is that anything that's been?
But it's an interesting idea to explore. Yes.
I think it gives a value as opposed to having recurring ones. It increases the value of missing 1 or 2 or 3, as opposed to missing the 1. And the 1 being, show me that this beautiful page is
Learn something, yes.
work.
So I think that was brought up on a case of abortion a couple of months ago by someone, I don't remember who.
It's going to get out.
They appreciate that.
Yeah.
I'm buying you lunch. Is
So
that,
you're saying to have only one TMP every 20 years?
No, I know.
Or to have the comeback?
It's just that with the TMP from PV documents, and then adjustments.
So that's what I'm trying to ask for time.
thank you, Commissioner Hampton, Commissioner Young, and Commissioner Treadway will take us off.
Do you happen to know when the SUP requirement for schools came in?
It was,
Second plan, like,
I think it was forever, we were looking into that, we see
It
it
was,
40s code.
in the 60s code, it was still not. It was, I think it was with 51 and 51. I'll give you a date. Sure.
We were looking in
Right,
at
so-
47.
so you go out there and you see some kind of improvement, whether it's a 6-foot fence or a light pole or whatever, and it's not brand spanking new. It's a guessing game as to whether that's legal non-conforming or just plain old illegal.
When we use our, reasoning ability based on how old it looks, and the history of the state, and
If it's a 6-foot fence and it looks like it's at least 20 years old, probably older, but it's probably not from the 40s or 60s, that's an illegal fence, not a non-conforming fence.
most likely. I mean, if we look, the other thing is, we look to see if it's ever been permitted. So if somebody thought to permit it and they were given a permit for it, it was approved by the city, that becomes a different situation. You assume they did that work to look up what was required.
Okay. And if it wasn't permitted, it's
It's
per se.
legal. Anyway, yeah.
Where the commission or council are going to impose height or story limitations, in your opinion, should that be done in the conditions, or is it sufficient if the site plan clearly spells it out?
I think that it needs to be done in the conditions.
And
We need
why-
to move away from site plan.
Why is that? We have one today that has 2 parts to the building, and one part says 1-story building, and the other part says 2-story building. If that's not good enough, fine, but why not?
It's because the text trumps the exhibit, as we know, that the most restrictive condition applies.
But under the circumstances, I think if the conditions were silent on that and then we had a story limit on the site plan, technically it would be the most restrictive, and so that would enforce.
And it would be eligible for a minor, but I would have a hard time seeing adding an extra story to qualify for a minor.
So this is where it gets a little bit fuzzy, and really the reason that we say put it in the conditions is because it takes away the fuzziness. So if you get to permitting groups and you don't have it in the conditions specifically, there's going to be a conversation that says, well, the SUP defaults to R75A and this and the other, and the text of our development code would rule over, sidewalks are a great example. Like, until we start putting sidewalk conditions in the language, they regularly went to permitting and got sidewalk waivers and had to install no sidewalks on the site.
Yeah, it's requirements for every single little tiny inch of every sidewalk that we added beyond 4 feet. And I can give you examples of schools that like conservative, they say the trail is sidewalk, yes, but the hefty sidewalk. And a permit, we issue a waiver for sidewalk. There's
So it's it is to remove that fuzziness and some of the discretion we don't want to be there.
Well, I take your advice. It boggles my mind that building inspection, look at a site plan that says 1-story building and sign a permit for a 2-story building.
I don't disagree with that. I just know that under production exists.
Warning, I'm going to use a 4-letter word. That is time.
Okay.
How long does a school typically last between what I'll call major changes, whether that's a remodel that changes the footprint, whether it's a scrape and rebuild? On average, how often does a particular school come in for zoning?
No, I don't really have an answer that I could give you with any certainty on that. I just know, for example, we already have a school coming back that is PD number 1097. So, I mean, it varies.
On the other hand, I've had a school in my district come back and they got their zoning 60 years ago.
Exactly. So we had
one in Carrollton Farmers franchisee, they did chicken and they got like 30 plus 30.
What I'm searching for speculatively is some benchmark. Every school we debate, should this be a permanent SUP, should it be a 5-year SUP, 20-year SUP, auto renewals, no auto renewals? I'm trying to identify how often is it that a school typically would be coming back anyway.
Depends on their bond program, right?
They need the bond.
or state laws to.
Or state laws.
Next question, signage. I take it since we're typically in a single family district, we're under the non-business sign regulations. Do those regulations, I've never thought about those as applied to schools. Do they permit the kinds of signs that schools typically want?
Man, where's Jason? So. They do, but the way they do it, there is a effective square footage of the sign itself relative to the height of the sign relative to the setback. So they get a certain base for certain setbacks.
I guess I'm learning something because, the sign in front of the school that says game starts 8 o'clock Friday night, go Panthers go. I didn't realize I could put that in my front yard.
So signs have their own setbacks. It's a completely different part of the code. They don't follow the standard setback. So what, the monument signs that you typically see where the support is the ground, very low, not pole signs or anything like that. They can be right up at the property line as long as they're not in a visibility triangle.
I guess I'm going to put a sign up at my house that says news of the young family.
Right. So yes, signs. And Jason created some really good graphic pages to kind of illustrate how it can be, and I think I told someone already that I was going to send that around, and I never did. So I'll get those from him and send them around just so you all can have a better picture.
Ms. Dre addressed this a little bit. The no traffic study, late traffic study, refusal to revise the TMP, and so on. The director shall notify the commission. And my question is how that's going to work mechanically, because it's going to be engineering that knows that one of those things has happened. but it's probably not going to be engineering that notifies the commission. And my concern is that there is an efficient and relatively reliable.
Well, the process that we have right now, and David can explain, David is letting our contest ladies know to send a letter to the school to remind them that they're due to submit their traffic study.
Okay.
So we do the same for basically. So David, I know he's a different department, it's ours, like, he works with us.
I don't want a year from now somebody to say, well, we haven't gotten any notifications. Is that because there are no schools? And have zoning saying, no, I didn't get anything from engineering, and engineering is saying, I didn't know I was supposed to send it to zoning.
We would never track them.
Thank you.
You said that was great. Thanks.
All right, and then once that notification happens, I kind of feel sometimes like a country that has nuclear weapons but no army. I get a notification that the George Washington Elementary School hasn't submitted its TMP since 1947. At that point, unless I can cajole or bribe or threaten the school into compliance, my remedy is to launch the nuclear missile and get 2 other commissioners and say, all right, we're going to think about whether to revoke your SUP. Is that basically right?
The conditions basically say that if they don't submit, the director shall forward.
All right, I'm talking about after that happens. What's the CPC's remedy? It seems to me, it's as I've described it, the alternative is to turn in a 311 request, and I might as well save the electrons.
That is not true. It has been effective. It's not the ultimate burden for people to go ahead and use, because it has been effective on school sites.
I saw recently.
So, 2 other questions, and then I'll shut up. Pretty much everything that we described today applies to non-public schools as well as to public schools. And likewise, charter schools, which are technically public schools.
Yes.
Final questions about TMP minor amendments. Are those school initiated? Like any other minor amendment would be?
Yes.
All right, and
It's never had minor amendment.
okay,
We're about to.
but okay, but in terms of our arsenal, and am I right? That's governed by roughly the same minor amendment criteria that govern site plan minor amendments and so forth. So, if we find that the minor amendment does not do any of the triggering things, we have to approve it.
I don't think it works the same way. But this is what I thought your question was about. Do we automatically have to approve it just because it's a minor amendment and it checks off certain boxes? The development plan minor amendment has an ordinance development code attached to it with very specific criteria, as opposed to a traffic management plan, which is something that engineering reviews for whatever they review it for. And it's not the same, there's not the same set of checkboxes that I'm aware of. There's some discretion staff needs to address.
So, for example, on a development plan minor amendment, not the initial development plan approval, but a development plan minor amendment or an SUP site plan minor amendment, we have the checklist, and if it checks all the boxes, we have to approve it. We can't say, well, this meets all the boxes, but we wish that 10 years ago we moved the dumpster, so we're going to require you to move the dumpster.
Right, you're correct. So
okay, but you're telling me TMPs are different.
Allegedly.
I say that in different background on different scenarios, and I know that I have seen David's hands tied more than once, because essentially we can ask till we're blue in the face to have a certain curb cut removed because it's not advisable to have a curb cut in that location. But technically, it meets the distance requirements from the intersection and there's nothing else saying, so we advise and then they end up doing whatever they propose.
I want to challenge Commissioner Blair here. Let's suppose that there's a TMP that's not working and people are queuing in the streets and neighbors that they're queuing in front of are brandishing guns and vice versa, and it's just a total failure. And the school comes in for a minor amendment and says, we really think red for our traffic cones would be better than orange. We have no discretion but to approve that.
I think the basic case for the traffic management plan. I mean, I'm sorry. Right.
Okay, so you say.
If you don't mind, if we're way late, then I would just like to say that I understand the TMP is the elephant in the room, but that process is the same for an SUP or PD.
Right.
So, and I think that's an important one that we need to iron out.
We'll defer that to briefing for along with the hour worth of questions I have about the application of the residential proximity slope in institutional uses and things like that.
Okay, all right. I heard that was like at 3:10.
Okay.
Yeah.
Thank you so much. And please circulate the questions and answers that were received from the Commissioner. It would be great for all of us to see the wisdom in. Commissioners, we're going to keep just powering through. If you need to take a break, please do so. Just be mindful of the forum, which is going to keep going. Good morning.
Yes. There we go.
Okay, we're recording. Eight, 9.
I'm presuming vice chair.
Yeah. Good stuff. I'm leaving at the roof. She's receiving on one.
Will you grab a car or grab my car?
An amazing person. Yeah.
She was right by the block.
Yes.
Look at me making a mess.
I'm hoping to think over
Yeah.
It's right there. Yeah, that dog used to go there. I don't know.
And we're not.
4 or 5 story home.
Well, they only use 2 floors. Yeah. 3 now?
Yes. You know, for our discussion not 10 minutes ago.
Well, and then, you know, my son goes to downtown Monterey and makes sure building with it's law. And it's guys but they're building a school right here next door to City Hall. Right now, I don't think it takes long.
Which is a application for a minor amendment to a development plan in PD 697. It's approximately 14 acres and it's in the Council District 9, and it is for an elementary school. It's located east of downtown, northwest corner of Buckner Boulevard, which is right here at Buckner Boulevard and Mercer Drive on the east. And the zoning around is residential. And the main changes or the amendments to the development plan are actually to the development plan.
to show you what. But it's some additional, a small entry vestibule, parking lot, driveways, fire lane, sign, and the landscaping. This is the current existing approved plan, and I apologize for being upside down, but I was kind of wanting to give you all the same perspective as we move through each phase. So here is the proposed development, amended development plan, and it's going on to changes. The enlarged version of development. So right around this area is my cursor, yes, is the additional vestibule, and then the new parking lot and drives with fire lane extending up to this area. And along with that comes the additional landscaping that has been provided in this area. There's trees that have been added north between the parking lot and Mercer Drive, as well as an additional planting area and landscape islands within the parking lot itself. And staff recommendation is to
Response to questions.
Thank you, Ms. Moore. One question, it looks like from the aerial that's in our case report, the expansion area currently is portable buildings located there. I believe that's where this new drive and parking area is going. Are those being relocated anywhere else?
So looking at the existing development plan and their development plan that you're looking at right now that they're amending does not reflect those. We don't generally go out to the site to determine what's out there on the site because the development plan is amended for amendments and would have to conform to the conditions of the code itself. So with that said, if that is where those are, then I would imagine that they are being removed to the park.
So if for whatever reasons things are located there, come back.
They should, yeah.
Because there's, I mean, they're in the expansion area currently. See that would have been allowed, it was just relocated. So,
yes.
Thank you. Thank you, Ms. Moore.
Thank you.
Yeah, just a quick question. I just want to dovetail on your former conversation. So you're saying that because this is being done as a minor amendment under the existing development plan, as long as it conforms to the existing underlying code, zoning code, we don't make any changes, additions, or whatever. Is that right? Yes. Thank you.
Would it surprise you to learn that the portables no longer exist on site? Okay. And I don't see Phil Irwin is.
It's not the end of the day.
He's taking the whole time.
Your opinion, the trees and shrubs between the parking lot and Mercer Drive provide an adequate buffer from the and across the street.
I would have to look at that more closely at this point.
Okay.
And I can stay in and do that, yeah.
All right, thank you.
Any other questions from the show?
I know I'm a rookie, so this is a rookie question. We talk about a lot of landscape plans, especially for the minor amendments. But how are we discussing irrigation? Like, are we getting water? Is there a process for ensuring irrigation exists on the properties for us, or?
Well, we would look at that when we have a building permit and construction and inspection process. We'd look for irrigation for that property. At this point, I wouldn't know what the condition of the irrigation is for existing landscaping.
Gotcha. Any other questions? Scales, please.
Yes.
Thank you, Ms. Warren.
And as the best to the table, I think you all were able to her last meeting, however, she nor I were present at the time. So this is Tizia, this is her. She jumped in with both feet. She joined our team the end of March. So this is her first synthetic mission. And she comes to us from Development Services, actually. She was on the Q team there. So she's very used to looking at development plans and minor amendments and site plans. So we're thrilled to have her join this team. Welcome. Good morning.
Did you understand this?
There's one here. Oh, I'm sorry. Oh, is this yours? Oh, this is no.
You got the director of the Commission House representatives. By the name, good morning, sir.
It's over there.
Case number 8. So Commissioner Book, while we're getting this queued up, case number 4 will be held under May 18th. We'll come back to number 5. This is Ms. Munoz. Do that. Yeah, we're going to 8.
I'm right here.
Okay.
Good morning, everybody.
Number 5 next, then number 4, held under advisory by 18th. We'll leave it then. Number 5, we have Mr. Record of Life in the 2 conflicts. But that's right. Or stepping out of the room.
We do.
Number 5, we'll come back to number 3.
Jason's ready.
We'll go to Ms. Munoz. Good morning.
Good morning. So this case is Z223120, and it's an application for a new sub-area on property that's currently within sub-area B in PD 758. The request size is about 4 acres, and they are trying to amend the provisions for sidewalk requirements due to some site constraints while they are in the middle of construction at the site. So a building permit has been issued here for a multi-family project. You can see the site highlighted here, and this is a zoning map adjacent that shows you the sub area. They're doing the southern portion here that fronts along Walnut Hill, and then this other portion over here is the northern half that would remain sub area B. Because it is only a portion of the sub area, they have to request an entirely new sub district or sub area for this PD in order to amend the provisions, because they are not including the northern section of this sub area. So currently underway is 2 structures. One is 4 stories, the other is 3 stories with 144 dwelling units. and plenty of parking. So construction's currently underway. You'll see those photos right now. And they are amending that southern tract due to sidewalk that they are trying to have exceptions for along Walnut Hill Lane, where the property is significantly lower than the right-of-way frontage. The property itself is located in Lake Highlands. It's on the north side of Walnut Hill, as you saw on that map, on the east of Abrams. And you see it here. It's got some interior right-of-way with Whistle Stop Place being to the north. And then to the west, we do have Wildcat Way. Surrounding land uses and zoning. So for the most part, to the north and south, north and west of the site is all within PD 758 different sub areas. And then to the east, we have SUP 740, which is for the Lake Highlands DART station. Farther to the east in the MF1 and neighborhood office zoning district, there's a child care facility, and then there's single family units as well. And then to the south, we have PD 1007 with multifamily, as well as PD 758 to the southwest, which also has some open space and then multifamily and retail all within that area. 758 was created back in 2008. It does have 4 sub areas with about 69 acres of land. The conceptual plan I'll show you in just a moment identifies those 4, but you can kind of see it on the map I showed you beside the aerial. Now, all sub areas are required to submit a development plan, and for sub area B in its entirety, one was approved by CPC in March of 2021, which I'll show you as well. Here we are looking at the site from Walnut Hill, and you can see that change of grade and how you can't see the whole new structure that is there. And we're looking down onto the site, and you can also see the DART right of way to the east of the site, and obviously the change in grade there. So we're looking at the sidewalk that fronts along currently on Walnut Hill Lane, and they are seeking to maintain this sidewalk, where the sub area B standard right now is for an 8-foot sidewalk with a 5-foot buffer between the back of the curb. So if you can imagine, minimum of 13 feet extending outward into this green area elevated above the site, about 20 feet from what I could see on the topography on the plan. That is a significant issue for them, and they are seeking relief from that by amending the sidewalk provisions for this section only. Now, here's a view from their driveway onto Walnut Hill and the remainder of that sidewalk as we look eastward onto Walnut Hill. Now we're in the interior on Wildcat Way looking into the site. You see all the new construction occurring. And from Whistle Stop Place, these are the adjacent land uses. There's multifamily to the northwest. There's a lot of multifamily coming up in PD 758 and also a mix of uses. This is all on the north side of Whistle Stop Place. As we get to the Lake Highlands station right here, which is all along the east boundary of the site. This is a look at that daycare facility that's located in the NO district adjacent to single family, and how the elevation changes here as well. And now we're looking farther from the site. This is adjacent to that daycare facility and private school. You see their sidewalk and how it fronts along Walnut Hill as well, and that also change of grade from the developable property down below. We're looking across Walnut Hill, where we also have a significant amount of density under construction or newly built, and a mix of retail uses and open space. That's the remainder of sub-area A there, also under construction. None of the development standards or land uses are being amended for sub-area B I'm sorry, I put D on this table here. I didn't realize that. It's sub-area B. None of those are being amended, so it's just going to be the issue of the sidewalks. This is the existing conceptual plan. Walnut Hill is to the south, and so the north is to plan left there, or plan west. And this is the section here that they are seeking to create a new sub-area for, including the right-of-way and the open space requirements that are shown on this conceptual plan. It's closer to 5 acres. The proposed revised conceptual plan, there were some issues that I noted, as including the acreage not matching, because, as I've been explained by the representative, it includes that open space acreage and right-of-way acreage, which is not an actual part of the build site. So they've submitted the request for the zone change based off of the build site. And so the conceptual plan shows those additional areas. And then additionally, the labels just should say sub-area rather than sub-district. The north arrow needs to be corrected because it shows plan north being the proper true north where it is not. And then finally, it's missing the detailed summary table, which was previously included here. They have amended that and provided it to me. It's still missing a couple more changes that weren't done by the time of this presentation. So Mr. Baldwin did say that he would complete those edits and show that to you at the hearing. This is the approved development plan. It shows those 2 structures, multifamily structures, with the one that you saw built closest to Walnut Hill Lane being the 4-story structure. And there's no sidewalk notated here on the development plan. So there will be no amendments required of this development plan. And that's just a close-up showing the details on the summary table for this section, which includes sub-area B having 2 different lots. The northern half that's on the north side of Whistle Stop, and then this southern half, which includes those 144 dwelling units on 4.057 acres, just like the area of request is. And with that, staff recommendation is approval subject to the revised conceptual plan as with the brief changes and conditions.
Thank you, Ms. Munoz. Questions, Commissioners?
So the exception is merely for the requirement of the landscape buffer in addition to the sidewalk, but not an exception for requiring the sidewalk to be there? I mean, since it already exists.
They would be maintaining that, but the way that the exception was written is that it would go under director review. It would not require the 8 feet in width, and it would not require the additional 5 feet back of curb landscape buffer. We would like to pare that down and limit it to just that section, but ultimately it would be under the director's review as written in the conditions.
And I noticed in the PD conditions, it mentioned a couple other conditions as well under the director's review, and also subject to a new sidewalk being built within a year or something. Is that actually a condition that will be met?
No, so it's an or circumstance.
Okay.
Basically, we took the sidewalk waiver language that currently exists and applied it to this PD, giving them the option to have one of those 3 in order to comply for a waiver through the director to meet some of those standards. It will not require that there be an exception or complete variance of sidewalk, but according to the applicant, that sidewalk was recently constructed by the city. It does seem to be in line with what exists along Walnut Hill, but in either way, they would be required to receive a waiver or to meet the conditions of the PD.
Thank you.
Treasurer.
I have a similar question. The third criteria that's in that list, and I just read it as ors, said if the waiver will not have an adverse effect on neighboring properties. So I was curious, were these 3 things, the safety, that will it be built within a year, and then adverse effect, are those all being added new, or did they exist prior?
These are the typical sidewalk waiver exceptions that a director weighs in order to accept a waiver of sidewalk requirements from base code or PD code, whatever. If it permits the waiver, the director has that under his purview. So those were not amended, they were just merely adopted to this sub area.
Okay, so just to clarify then, the director, as part of the director review process, would be making the determination if there was a waiver, whether 1, 2, or 3 was met.
Correct.
And these are standard, they're just being added into this PD at this time.
That's correct.
Thank you.
Thank you. Commissioner Herbert.
Yes. So, so it's not that those sidewalks won't be built. It's just the requirements that we're asking them to build it. They're asking for a waiver on that.
Yes, that's correct.
Okay. And do we know what their proposal will look like, or even have an idea of what they're going to propose, especially the area off the side of the bridge? It is unsafe, right? But do we leave it that way, or how are they going to improve it?
Yeah, honestly, they're seeking to maintain that. So they're saying that those sidewalks are still in good condition, were recently installed by the city. They're 4 feet in width at back of curb, and they're seeking to maintain those existing conditions. And in the section that they have to remove or that was not existing, and right to the west of their driveway, they're seeking to align with that existing condition.
Thank you. Yeah. Commissioner Young.
Looking at Google Earth, it appears to me that as you move north of Walnut Hill, you've got the substandard width sidewalk, and then you've got a ramp that I think is pedestrian ramp that's leading people to the DART station. Is their driveway going to cross that pedestrian ramp?
That pedestrian ramp and a whole pedestrian path crosses through the west side of the property, and that's away from the, I think it goes around the site instead of through the driveway, which is more to the east of the site.
Okay, thank you. Any other questions on this item, commissioners? Okay, we'll go back to case number 3. Thank you, Ms. Munoz.
Thank you.
Ooh, we're ready for you. The record reflected Commissioner Hampton. That's right. It's that way.
Okay, this is for case 223-009.
Yes.
A request for a minor amendment to existing SUP site plan. It is the SUP 2289. It is zone CR community retail with a D1 liquor control overlay. Area request is around 0.8264 acres, and it's in Council District 9. Here's location of the property within city limits. It's located at the west corner of Garland Road and Beachview Street. Here's a little back history. On April the 25th of 2018, SUP number 2289 was established for the sale and service of alcoholic beverages in conjunction with a restaurant without drive-in or drive-through service. Here's some request information. So the request is to amend the existing SUP site plan to allow for the relocation of dumpsters, additional parking, and deletion of outside patio to replace with landscaping. Here's an aerial map showing the property in red, and then some adjacent properties around it. Kind of south, north and southeast, we have LO1, which is limited office, and then also another CR district, and then to the west we have north and south, we have like a multi-family
and also a MU2 that has a standard affordable housing overlay. I'm sorry, it's wrong. And here is the existing HUP site plan that was approved. Here's an enlarged one showing the existing screen dumpster, and then also the existing configuration of the patio and the parking. In front, they had 2 patios and 3 parking spaces. Here is the proposed site plan. And here's the enlargement showing the dumpster now running along Beachview Street, and then also the reconfiguration of the parking and patio. They're going to reduce the patio to the west as landscaping, and they're going to add additional parking space on the other side of that handicap space to the east. Staff recommendations is approval. This concludes my presentation. Thank you.
Thank you. Mr. Young.
It's correct, is it not, that the improvement, the changes that they're requesting have already been made? They were made at the time the building was built, and this is to bring the building into conformity.
Any other questions, commissioners? Got some great questions. Good job, Ms.
Wait, the real question is, was her mom watching? Yeah, my first one, I was like, you don't have to be nice. But it was real in my case.
Commissioners, we'll keep going. Okay, so we've briefed number 5, number 6, and 7. Both will be held under advisement from May 18th. 6 and 7.
May 18th.
May 18th, 6 and 7.
And we didn't skip 2. Yeah, we
went back to
that was just no. Yeah.
And Mr. Moulton. By the way, Commissioner, when we get this set up, Mr. King put out some of the annual forms and the quarterly reports. He has some out there for you.
Oh,
Want to go ahead and do that? Fill them out and turn them in today.
Okay, good morning, Commissioners. First case I have for you today is C-223-103. This was held under advisement at the last meeting. We were given instructions to re-advertise for a WMU5 district. So yeah, that's what we're doing. The request is in a new mixed-use district on properties owned in IR Industrial Research District with consideration for a WMU5 walkable urban mixed-use district. It's located on the southeast line of Empire Central Drive, northeast of Perry Hines Boulevard. It's approximately 1.85 acres. Location map showing the property is limits. Aerial map with the area request outlined in blue. And coming up here in a second, the zoning map with surrounding zoning districts and land uses. So most of the property along Empire Central is zoned IR today. However, I've been here long enough that I'm looping back around to cases I had when I first started, when it's a flat circle. I had 2 cases on Empire Central that were recently rezoned to M2 with some deed restrictions. A little further out to the north is a single-family neighborhood zoned MF2A. There are single-family and multifamily uses within that neighborhood. Northeast along Empire Central are on-site storage and some office showroom warehouse uses. And then these 3 lots here, they're actually surrounded by that office showroom warehouse. Those are single-family today. Due east is a multifamily use of the PD 759. It's sort of a mixed-use PD. Southeast, other office showroom warehouse uses. South, so MU2 is a commercial parking lot, and then to the southwest are office and community service center uses. So the property multifamily MU2 district. However, as I said at the last meeting, the case was all under advisement with instructions to staff to advertise for W5. So the case report and my briefing today will include consideration of that form district. This is what is shortly quickly becoming our kind of boilerplate overview in our presentations for form districts. I just wanted to go through it because we've had some new commissioners recently. So in general, form-based zoning differs from traditional zoning in that the development standards focus primarily on the form of the building and the design, more so than the intended land use, although Article 13 does include some land use regulations as well. Under this kind of zoning, the desired form of buildings is typically more urban in style. It's characterized by multiple stories of a building in the front of the site, closer to the street, create a better streetscape and pedestrian realm. That combined with standards for street frontage minimums, transparency minimums, building articulation, and pedestrian amenities, it lends itself to more urban, more walkable. It's intended to ensure an active streetscape that encourages pedestrian activity and screens parking from the pedestrian realm. Some of the benefits to property owners include additional buildable area, increased height, density, and floor area, and reduced parking requirements that encourage the use of multimodal transportation. Form districts are intended for neighborhoods with a dense urban character and a high walkability. So this is a sort of okay example of what you'd see in terms of development standards under traditional zoning. You see a front yard, you see a side yard, a rear yard. Can be different for corner lots or interior lots. But, that's usually what we're focusing on in terms of development standards. It's just the siting of structures on the property, how much of the lot can be covered by structures, and so on and so forth. This is from Article 13. Form district regulations get more sophisticated. For example, here you see that there are minimum street frontage requirements. So under the proposed district, a minimum of 70% of the structure has to be located in the area between the minimum and the maximum setback. That's another thing with form districts is there are maximum setbacks in addition to those minimum setbacks. And then these are more images from Article 13. Different regulations for the ground story of buildings, which, based on the development type you're looking at, commercial uses on the ground floor and residential above, things like that. And then in terms of facade requirements down here, for this form district, there is a maximum blank wall area on a primary street of 30 feet. So we need to see articulation or architectural features on the facades of the building. There are requirements for transparency, both on the ground story and upper stories, stuff like that, just more nuanced requirements. These are some examples from Article 13 of kind of what that can look like in these dense urban areas. So moving on from that, some site photos. This is on Empire Central Drive looking east. It's just the frontage of the existing property. And this is on site looking at those buildings. And surrounding uses on Empire Central Drive, we're just going to start here in a clockwise direction. See some of those existing industrial uses that are still valid on there today. There's one of the existing multifamily uses to the north. So these are the development standards for the existing IR district and the originally requested MU2 district. Just in a base MU2 district, there are some incentives built in terms of sort of development bonuses. If the mixed use project is provided, you start at a base density of 50 dwelling units per acre, but if you have a mixed use project with 3 different uses, you can go all the way up to 100 dwelling units an acre. There's a similar kind of incentive built in to height as well. All of that is still subject to RPS, urban form setback, tower spacing, visual intrusion, and all that kind of stuff. And then these are the incentives available to a base MU2 district if mixed income housing is provided. In my conversations with the applicant, they have not indicated an intent to provide affordable units, but because this is a base district, they could potentially receive the bonuses listed here. So there's 3 different kind of tiers in an MU district where you provide a certain set aside for affordable units at different income bands. You can get bonuses to density and then also remove the FAR requirement for residential uses. So it's just some staff consideration related to the WMU5 district. And we saw that more or less the critical mass requirement is met for this area. As I said, the surrounding area is transitioning to a dense urban character. It's kind of in the middle of that. There's also proximity to existing multifamily, mixed use, and comparable planned development zoning. PD 759 to the east is definitely a good example of that. Although it is not within the boundaries of any area plans, it's just outside the boundaries of both the Stevens Corridor and Trinity River area plans. Both of those really recommend high density zoning and land uses as well as an enhanced pedestrian experience. It's located within a 10-minute walk of a proposed rail line, and then it's also within 1 mile of the Inwood Lovefield Dart Station. But that's pretty much as close as it gets to rail transit. And then I will note that this Dart Station is identified as a strategic opportunity area in the Stevens Corridor. So with that, staff recommendation is approval of a WMU5 district in lieu of the original MU2 district.
Thank you very much. Mr. Trevor.
So this, I'm all new to this whole form stuff. So if I read it correctly, this would, there's a subcategory. This would be in multi-family living use category within the apartment development type.
That's correct. Yes. So there's kind of kind of the best way to explain that is there's sort of a hierarchy, kind of like getting into Article 13. You start with what district is being requested. So that's like a WMU5 or WR3. Those are some of the different form districts available. Within those districts, there are development types. It's kind of a subcategory that are permitted. So the apartment type is one of the development types. There's also single-story shopfront, townhouse stack, which is the ground floor is commercial, the upper story is residential. Several different development types that are allowed within the district. And then within those development types, there are different use categories permitted. So in this instance, the zoning district is WMU5. The development type within that is apartment, and then use category within that is multifamily.
Say that again. So what is regard this category?
WMU.
WMU?
WMU5, that's the zoning district or the form district.
So that's not mixed use. It allows for it. The question would be if there is mixed use, it allows for mixed use. Is that correct? The district is allowed.
Right. That's one of the many development types that's permitted. Is WMU.
So that's number 1. And number, then you drop down to you're in the apartment and development type.
That's like the second tier.
And within that, you are a multi-family living use category.
Correct.
So to Mr. Hopkins' question, when I read through these materials, it looks like there's no commercial or business use here. no hotel or lodging use there. But you do have personal services. So like, how do you just really down to see exactly what is allowed here? Because where I'm going with this is, what is the benefit of getting it in 5 over the 2? Although it's not yeah. So more specific design standards getting, but then but the whole thing about no MIHB being available, that's true. Don't we want to encourage affordable housing? And if you're serious development towards this form-based zoning, how do you also encourage affordable housing?
So to address your first question about the uses allowed in one of the mixed-use form districts, this is what I have on the screen from the case report. It's not apples to apples to do a land use comparison between one of our traditional districts and a form district, because again, the form district is focused more on the form of the buildings, although our form district regulations, Article 13, do have some use regulations kind of built into them, but they're a little broader. So what this does is kind of these first 2 columns, it's what's permitted under Chapter 51A and IR, and of course the original MU2. And then as comparable as we can make it, what use categories correspond to those uses within Chapter 51A. So you can see within the mixed use development type, single story shop front, general commercial, and townhouse stack development types, there are several different office use categories allowed, like medical and office. Scrolling down further, here's the residential uses that are permitted in WMU5. Retail uses like drive-through facility, restaurant or bar, retail sales, these are all the kind of commercial uses that are permitted. Personal services is one of them on here, stuff like that. And then your second question was about affordable housing.
So hold on, so you're saying that because of the MU, that all of the use categories in the 3rd column under MU would by right to be permitted if you go with this WMU. Correct.
Yeah. So the proposal from the applicant is for what Article 13 we call multifamily living, multifamily residential. But if the district were approved, it would also allow these other development types like mixed use, single story shop front. And then based on what development type is proposed for the site, if it's not apartment, it would also allow these other uses under those development.
Okay, so I'm getting more curious. So are we not approving the apartment development type as part of this discussion?
You are, yeah. What's under consideration? This is, although it's a form district, it's still a general zoning change. So we're just considering if a base district is appropriate for that. But as with any other base district, we're not 100% on what specifically is being proposed. It allows for broad range. It's just like any other. If this was an MF or a standard multi-district, it would be the same kind of consideration.
So what are we approving?
The question is if WMU5, the zoning district, that top tier, is appropriate for this.
And do they have to come back if they want to do something that's not apartment or multifamily?
No, yeah. So all those development types and use categories can still be permitted. So after, if this zoning is approved as WMU5, it entitles them to all those other uses. Which at WMU5 in terms of permitted uses is comparable to one of our standard mixed use districts like MU1.
So we're really giving us quite a large swath of things.
The mixed use districts do, because they're intended for a mix of uses, do allow a wide array of uses. But in this instance, we feel that's appropriate because this area is in transition to a denser, more mixed use area.
So, okay, I'll let you go to the MIHD.
Yeah. So we will actually have a case on May 4th where a PD is proposed with a WMU5 base. And then, because it's a PD, we can build in that mixed income housing language that would entitle bonuses from that base in U5 to height and something else. Yes, thank you. So that's the solution that we have found where we can have these great design standards for districts, but also permit mixed income housing. I wasn't here when the mixed income housing development program was being developed. I'm guessing the intent with not including form districts in what districts can have development bonuses is that there's already so many incentives built into Article 13 to get those development bonuses to like height and lot coverage and everything. So the thought may have been that we didn't need to add this additional level of bonuses to Article 13, but the point remains the same today. We don't have those bonuses allowed in the form district.
My rudimentary understanding though is that the design standards give the density without requiring.
Right.
I am getting that.
It's still sort of incentivizing, but what a developer is giving to receive those incentives is these increased design standards from the form district rather than affordable units.
Okay, at some point, I gotta say this next time I have to stand.
Article 13 is very tricky for us. Yeah, I would say out of all our current staff, I'm probably the closest thing to an expert, but I would not call myself an expert on Article 13.
Why does it do this? Because it adds the standards to the code. The code is a land use code, which is the old type of doing something.
But you can do that for a PD.
They don't want to.
But now you're going to have to back into a PD or district in order to get the affordable housing bonus. Like, to me, this is the tail wagging the dog.
Well, but that's really the only thing that could be considered missing from Article 13. There's a lot of other great benefits to Article 13 that are already built into these standard zoning districts. They're
But
already
it's not affordable housing, which I gotta say seems like a fairly large thing.
They have one, but it's so not.
It's kind of parking. If I may, Mr. Chair?
Sure.
Mr. Monkey, is it correct that in Oregon's code that there is an affordable housing provision that is structured around parking relief?
That's correct, yeah.
And that the bonuses that come in related to the district, again, this predates MLHD in terms of our code.
By about 10 years.
We may think about how to incentivize affordable housing. Parking was identified as a challenge to that. This code did that, and then we had information built in some of the design components of form, getting parking behind the front facade of the building, requiring primary entries, transparency, so we don't get blank facades facing the right of way. We limit driveways by that facade frontage requirement. Things that promote walkability, which is kind of one of the underlying using a walkable district. Is that correct?
That is correct, yeah, and just to add to that, some of those great design standards are incorporated into the mixed income housing development program. I would say between the two, Article 13 is probably more robust, but yeah, that's built into the mixed income housing as well. And yeah, as with all things, it's important to know the history of our code. You know, Chapter 51A was adopted in 1987 initially. Article 13 was not adopted until 2009-ish. It was actually yes, thank you. Actually, PD 74 for the Trinity River corridor. That's pretty much Article 13. Like literally like a year before Article 13 was adopted. So that one's really tricky too. But that's just the sidebar.
So the cadence is base zoning.
Yes.
Form zoning. Form. And then MIHD.
Correct.
If I may, so two other questions I wanted to ask. This, I think your case report laid out, by moving to the WMU standard, the project will more fully comply with some surrounding area things. Is that correct? Yeah, the chart that showed when there was additional.
So, right, so yeah, I kind of, in the case report, I try to be, pretty fair and balanced about it. We've had some other recent plum districts we've recommended where it was more of a slam dunk, I would say. It was in an area plan, and it was like within a 5-minute walk of a DART station, but there's still a lot of compelling reasons here why we feel this meets that critical mass requirement, especially the surrounding complex.
That is getting my follow-up question. I think you mentioned this, the trend on, call it the south side of Empire Central, Northfield West, the 759, that's all 5-story multifamily that's developing fronting onto Empire Central, is that correct?
That's correct.
And then when you're on north side of Empire Central, the recent cases that we have been MF2, which then matches the adjacent base zoning district that then goes into, I'm going to say the neighborhood. I can recognize there's single family on ground. Is that kind of the context of the development of this area?
That's very accurate.
Yeah. Okay. And then in your conversation with the applicant and with the CNP, it's included in here, they're proposing multifamily development. Is that correct? The base code, anything that's allowed could be developed.
That's again, this is a general zoning change, but the indication we received is that they intend multifamily.
Where part of the reason why they specifically requested the mixed use is that there is an existing office building on the ground.
I am now.
Should the applicant will be here later today, we can extend that question as well. Final question in the TNP, there's a site plan that's included in there that was not be compliant with the NV3 that's now proposed, correct?
Yeah, so for a general zoning change like this, any kind of traffic study is provided as part of the docket for your benefit, for the benefit of the public. Unlike, we discussed earlier, unlike the PD or an SUP that would have a traffic management plan in certain instances, it's adopted as part of the ordinance. That would not be the case with the general zoning, it would just be the zoning.
Are you aware if there was community outreach on the project and the feedback that came from the community?
I have not received anything from surrounding residents or any kind of information from the applicant. I can give you my lane boilerplate response that we always encourage applicants to contact the community.
I want to be sure to ask the applicant to address that, and I can say that I have been in touch with the adjacent neighborhood association, and walkability is something that is very continuously comes up in reviewing these cases. This is, I believe, our fourth case we need to have something to mention. Final question the adjacent neighborhood association, are you aware if they're pursuing a neighborhood stabilization overlay?
I am not aware of that. I will say, so the time is a flat circle thing. The first cases I had on this street on the north side adjacent to that single family neighborhood that is to a Commissioner Standard's predecessor voiced a lot of frustration with the fact that there are existing single family uses there, but they are not entitled to the protections of single families.
Thank you. Thank you, Mr. Chair.
Thank you, Commissioner House.
Mr. Mulkey and Mr. President's questions about the mixed income housing bonus relative to WB5 addressed the majority of my question. My observation in that general realm, well, I'll state in form of a question: why would we in WB5 require minimum parking that exceeds what would normally be provided? I mean, it's trying to be something that's more walkable and more.
It's my understanding that when we did our culture team, it didn't start like that. But
it's got too much work.
It didn't there a lot. And it has a lot of options to reduce it, but in the end, if you put a cumulative, it still reduces by 10%, which is something that's already overboard.
So something to be addressed at a future date.
Anything on this one, too? No? You did, you're on the list. Yeah. We have Commissioner Kingston, Standard, Hopkins,
Carpenter, yeah. Commissioner Casey.
Thank you. This is more of a question than Commissioner Treadway discussion. We've seen some housing that's not being public affordable housing that could go into
Could you elaborate on what other types of affordable housing?
Sure. Like DHFC housing could go there, or like that, other types of housing could go in any housing project, right?
Yeah, that's a little beyond my end, but if the use would be considered multi-phase, then yeah, it would be allowed in an MU2 or another.
Thank you. President Foster.
Building on Commissioner Hammond's questions, and there was some concerns about walkability, looking at how the neighborhood is transitioning, hearing that there's some other walkable form districts that we've been approving, and that the train station is a mile away. And this is a highly industrial, highly auto-oriented neighborhood in general. I'm glad Mr. Navarez has stuck around this long.
I am too. This is something that's pushing up here.
Are there transportation design changes planned for this neighborhood at all, or is the zoning taking the lead on the walkability here?
Thank you for your question, and I appreciate the way you phrased it, because it's very obvious that someone is taking the lead. In fact, we are reviewing, and the applicant is urgently asking for us to release plans to construct their next door property immediately adjacent to doors. We asked for upgrades to sidewalks, and it was a battle, a really strong battle, where we had to explain why a 5-foot sidewalk was better than 4 feet. And that's just next door to this property at the corner, which is paved. If you look online, you see trucks queuing on the street that is just around the corner. And it's a pottery, I think the name of the development is Pottery House, but not Pottery. Yes, and I can't exaggerate, their whole frontage was a driveway, and we asked them to reduce it to 30 feet. They're begging us to move forward with 35 so that their trucks will bring it out. Zoning is definitely leading to any upgrades in this district, specifically on this one.
Do you know whether the upcoming bike plan, revised plan, has any additional recommendations in this area?
Nothing tangible for this road. Nothing planned.
Thank you.
Mr. Sam.
Yeah, mine is not a good question, but anyway, it sort of goes with, and I have the expert, Commissioner Hampton and Ms. Volkes, but that's why I'm going to ask you this question. Because I'm just curious about something. To me, I still think of this Empire Central area as an industrial area that is transition, don't get me wrong. But I guess I'm wondering, what is the philosophy of the staff? This is what I'm curious about. When you decide to make something an urban form in what's transitioning from an industrial area, okay, and make it walkable, then still right now, as Commissioner Plum says, it is an automobile-oriented area outside the urban area. So what is the criteria to staff? Are we to assume that everything's going to be put into urban form? And by that I mean moving up close to the street and this kind of thing, form-based.
Yes, I'll share my presentation here. It's a shorter.
I mean, if someone came and said, I want to build one of these 6-story standalone buildings that's set back in the middle of the, would you ask them to make it urban form? I'm just curious, general trend.
Yeah, so first I'll give my lane boilerplate responses that, the basis of our analysis and recommendation is zoning and land use. So what are existing zoning districts? What's proposed? Is that appropriate? Is that suitable, et cetera? Same thing for land uses. Beyond that, though, you'll see here, this is kind of a summary of what's in the report. Article 13 gives very detailed kind of metrics of what's called a critical mass requirement. So there's a few different ways to meet that critical mass requirement. But basically it's what Article 13 says is look at the surrounding area. Is there already existing multifamily mixed use or comparable plan development zoning in the area? That would kind of indicate that the area is indeed transitioning to something that's more urban and walkable. Are there adopted area plans for the property that indicate that the area is trending in that direction, or is the vision to go in that direction? Is there existing rail transit in the area? I think Article 13 is as specific as like a quarter mile to walk. That's pretty standard for transit-oriented development, a quarter mile walk. There's a few other things that slip my mind, but there's basically sort of a constellation of qualities that we're looking for in the surrounding area, and if some or all of those are met, it might be a good consideration for more districts. Like we said earlier, zoning is very discretionary, so there's still some interpretation there and difference of opinion. But for a form district, that's really what we're looking for. It's certainly not appropriate for all areas, which Article 13 makes very explicit. Is that your question?
Yeah, I mean, I'm sort of like, I don't see that as an urban farm area myself, and I see that it's far enough away from some of the districts you're talking about, or the medical districts and this, that, and the other. And it's not really near, I know that there's proposed to be near transit, but it really isn't near public transit. It is a very much industrial warehouse district, so it's just interesting to me the philosophy to put something so urban in the middle of that district, but it's just going in over philosophy.
But like I mentioned, those two cases I had right after I first started, those have some deed restrictions with them that provide some protections to the neighborhood. But then both of those projects were proposed as mixed income multifamily housing. And because it's a standard zoning district, they're going to have to meet all the standard design requirements of mixed income housing. You are? It's provided. Yeah, again, because it's based district. And it's an incentive, it's not a requirement. But yeah, so I did my best in the case report to be fair and balanced, but also give credit for the fact that there are some elements present that would lend itself to a good spot for all this.
Thank you, Commissioner Carpenter.
My question has been going back and forth with you, but it's very clear to me from the settlement to the city that y'all are also talking, they were looking to take advantage of the increase in the parking reductions. And one of the few things that there's six and not much else for based on that. But it seemed to be that the parking reduction they were looking for was, in excess of what was in the form-based zone. And I'm wondering, I guess my basic question is, does the affordable housing part of form-based zone get us to the same place as the big house? All else equal, what are they going to do?
In terms of number of units or parking, or
no, I mean, what they're trying to do, the number of units and parking reduction is it even going to be feasible with the form-based zoning requirement? This is going to get to parking reduction that we could get. And even if they were, it would result in the same number of affordable.
That's a good question. But this is a general zoning change, so it's
I'm just trying to understand. I think one of our major goals in their case is I'm just trying to understand does it give us inquiry so they qualify for whatever they can make it work the market and density. Does it result in the same?
That is a question that might be best answered by the applicant. Yeah, but if we have specific plans, all that kind of stuff, we could look at the parking table to make those comparisons. Right, yeah, it sounds like from Commissioner Hassard's comment earlier and Dr. Adriana's response, that parking in our building is a bit of an issue. Whereas in, especially since the amendment with the mixed income housing program, I don't think we can get much lower than 0.5 space per unit.
Yeah, about there.
Thank you, Commissioner Young.
Yes, my question is, you know, you're the first staff member I've encountered that understands the critical mass requirement and takes it seriously.
Because I'll tell you why and I'll tell you why that is because I had the first case I had where I wanted to recommend a form district. This is also in Commissioner Hampton's district. I went back and I looked at old cases and I looked at old videos and the meetings for those cases and I saw how vehement you were. Okay, I need to know my audience here. I'm making a sales pitch. That's my audience going to say. What you need, and I gave you exactly what you need. So. Good job. Yeah, you work. Here's the heck of And yeah, I mean, just to, you know, what we do here, guys, is tough sometimes. I like to celebrate victories and progress where we can, even if they are the teeny tiniest. Like that case was 3 lots, and then we had 2 more on the street that were really 1 lot each. But like, that's especially now that our team, speaking as the manager now, not as the player for this case, but especially that our team is now in planning and urban design, and we're really trying to have a more holistic perspective. This is what Jennifer has been doing as well. Like, we're looking to, you know, still do our incremental case-by-case work, but start to look for thematic connections. Like, I think I've had 5 cases lately where it's like a duplex in a single neighborhood, and I'm really trying to like expound upon that and think about it as much as we can. And this is another instance where it's like, okay, like let's take a moment here to really consider something new and novel that we really haven't done before, what we need to do to kind of push that. And once we've gotten to that place, you know, now we're to the point where I don't even have to recommend the form district, the commissioner is doing it for me. So that's just great. I love this.
Any other questions, commissioners?
Oh, yes. I was going to ask you this later, but you brought up that the Waffle Mixed Use District has building articulation. What is that exactly? Is it just changes in facade? Does it Juliet balcony count, or does it need to be like weird material changes? And
it can be a few different things, and one of the architects could probably answer that question better. But yeah, it's recesses and projections, or it's changing materials, or balconies could count. It's just physical features along a facade that avoid just a big blank.
Awnings, anything that kind of
space between windows. I saw like blank spaces between 2 windows are important. Pretty cool.
It is specifically defined in terms of chapter 13, what they consider that. It's usually steps in the facade greater than 12. So.
Any other questions, commissioners? Okay, on that high note, we're going to go ahead and have our lunch. Commissioner will just brief each case as we get to it at the hearing, so I think he's briefly asked my commission exactly at noon. Enjoy your lunch. We'll be at the Horseshoe at 12:30. Yeah. Gotcha. Getting back like that.